श्री भर्तृहारी मेहताब जी।
बोलेंगे लास्ट में।
मेहताब जी।
Thank you, madam. I have raised objection to the introduction to this bill, which is being amended again. This is with regard to the introduction of Arbitration and Conciliation Amendment Bill 2020 that is listed today and has been introduced as it has many ambiguities. For example, Section 34 does not contain any express provision for setting aside an award or refusing its enforcement. If the arbitration agreement on contract, which is the basis of the award, was induced or affected by fraud or corruption, if a ground is not available for setting aside an award, how can it be available to an applicant seeking a stay on its enforcement? The language of Section 36 is in conflict with that of Section 34. Thirdly, the mandate to unconditionally stay the enforcement in cases of corruption lacks logic or reasoning. When court can exercise its discretion to put an applicant to such term before granting any stay order, this reverses the effect of the 2015 amendment to the Act, which had done away with automatic stay on enforcement or arbitral award. Reason for this major step back. Lastly, madam, this bill omits the detailed criteria for accreditation of arbitrators introduced by 2019 amendment to the Act contained in the 8th schedule. In any event, it remains uncertain how the Indian courts will take a prima facie view in relation to the involvement of fraud or corruption in the contract, arbitration agreement or arbitral award at the enforcement stage. If this issue has not been previously raised between the parties, it will be different.
By me while giving the detailed reply, but very briefly, what we are doing, even the Section 34 now, with your experience, you know it very well. If it is against public policy, namely fraud or induced by corruption, it will be a ground for setting aside the award. What we are saying is, many fly-by-night operators get awards based upon dubious agreements and seek enforcement not only in India but also outside. Therefore, to contain those elements that is there, it will go before 34, but enforcement will be stayed at the prima facie level. Therefore, there is no point at all, with the greatest respect to him. As regards the competence of the arbitrator is concerned, madam, what we are giving the power now, instead of in the Act, it will be decided by the Arbitration Council of India. Who shall be competent, who shall be not, and the entire provisions are there, and all the regulations made shall be placed before the House itself. Therefore, there is no lacking of competence, there is a purpose,